This lecture is on 501c3 organizations. There's been a lot written and much interest recently in how to operate a church or a mission without it being a 501c3 organization. A 501c3 organization is known as a tax-exempt charitable organization. And those who contribute to these organizations can deduct their contributions from their federal income tax forms. It seems that most churches and most missions have become 501c3 organizations for the purpose of being able to receive donations, receipt those donations, and have the donor be able to receive that tax deduction. In most state income tax bureaus allow the deduction for the contributions to the 501c3 corporation basically because state departments of revenue are based on the internal Department of Revenue model. Now, in the last probably 30 years, there has been a tremendous increase in the number of organizations that have become 501c3s. Why? Well, I think the chief culprit are attorneys. Because you see, attorneys are trained in statutory law. That's the law passed by a legislature. Attorneys get some training in constitutional law, but the vast majority of it is in statutory law. And because of that training in statutory law, if you go to an attorney and ask him a question, he's going to look to the statute books for the answer to the question. And if he can't find the answer in the laws of the state in which he's practicing, the stock answer is you can't do it, it's illegal. And since about 1935, there has been a tremendous increase in statutory law. It seems that as Americans, we've taken to heart that old saying, there ought to be a law. And we have convinced ourselves that there should be a law regulating every aspect of our existence. Does anybody know what law is? Law is the low watermark of human behavior, the absolute minimum level of acceptable conduct that a person can do without getting into trouble. And even though that's the definition of law, it goes further than that. On this low level of human behavior, the highest law is constitutional law. Somewhere down below that is statutory law, and down on the floor level are regulations, regulatory law, the regulations of federal and state agencies. So what I am telling you is, if you use the law as we understand it, not the Bible, but law in the other context to regulate your behavior, you are only regulating behavior at the lowest acceptable human level. And if the behavior is regulated by agency regulations that are written up by the agency and printed in the Federal Register, not passed by Congress, life is being regulated by the vermin that crawl on the floor at your feet. That's the law that's one of the more common ones. In the 1880s, the Supreme Court of the United States of America, in a case called Norton versus Shelby County, told us that any law that was not in harmony with the Constitution was no law at all. It conferred no rights, imposed no duties, created no office. That it was of the same effect as if it had never been passed. But in the little over 100 years since then, courts, attorneys, and legislatures have forgotten that basic principle of American jurisprudence. Any attorney who professes to be a believer in Christ or in the Holy Bible needs to be reminded of Christ's words in Luke 11:52. Woe unto you, lawyers, for ye have taken away the key of knowledge. One of the ways the key of knowledge has been taken away is the laxity with which attorneys, particularly so-called Christian attorneys, go about counseling with regard to churches and missions. I'd fear that most Christian attorneys will have a very difficult time defending themselves before the judgment bar of God. Title 26 of the United States Code, also known as Title 26 Internal Revenue Code, they are one and the same. Section 501c3 gives us the definition of a tax-exempt organization. Section 501 is exemption from tax on corporations, certain trusts, etc. C3 is the list of exempt organizations. I'll read you what the statute says. Corporations in any community chest, fund, or foundation organized and operated exclusively for religious, charitable, scientific, testing for public safety, literary, or educational purposes are to foster national or international amateur sports competition, but only if no part of the activity involves the provisions of athletic facilities or equipment, or for the prevention of cruelty to children or animals, no part of the act, earnings of which inures to the benefit of any private shareholder or individual. No substantial part of the activities of which is carrying on propaganda or otherwise attempting to influence legislation, except as otherwise provided, and which does not participate in nor intervene in, including publishing or distributing of statements, any political campaign on behalf of or in opposition to any candidate for public office. Now that's word for word right out of the law for 501c3s. And I'm going to be the first to admit that this is somewhat confusing and it lacks the basic clarity necessary to understand exactly what it's saying. So, for every statute passed by Congress, there is supposed to be a corresponding regulation printed in the Code of Federal Regulations, known as the CFR. And if the law book, the laws for Title 26 might take up this much shelf, the regulations for Title 26 may take up 4 times that much shelf in a law library. So the corresponding regulation for 26 Internal Revenue Code 501c3 is found in 26 Code of Federal Regulations 1.501c3. And where the statute that I read a few minutes ago only has 113 confusing words, the corresponding regulation in the Code of Federal Regulations takes up 6 pages to explain that 133 words. The 6 pages cover such items as organizational tests that must be met, the types of provisions that must be in the articles of the organization, and what's to happen when those organizations are dissolved. Before going further, though, you need to understand some basic terms. Why? It's because law is words, and words have meaning. And if you don't understand the meaning of the words, you cannot understand the meaning of the law. Now, I'm sure you're aware of the fact that there's medical dictionaries because doctors use words. And if you don't know what the meaning of the words the doctor uses, you don't know what he's talking about. There are also law dictionaries because law involves words. If you do not understand the meaning of the words from the law dictionary, you have no idea what's being talked about because law commonly uses everyday English words, but they do not have the same meaning. So you cannot look at a law and pick up Webster's or Funk and Wagnalls and understand what the law says. You have to go to a legal dictionary to understand what the law says. We're going to define 3 words using definitions from Black's Law Dictionary, 6th edition. These words are articles, dissolution, and organization. First, articles. The subdivisions of a document or a statute. A contractual document executed between parties containing terms of agreement, such as articles of incorporation. The basic instrument filed with the appropriate governmental agency, normally the Secretary of State, on the incorporation of a business, sometimes called certificate of incorporation, articles of organization, articles of association, or similar names. So, when it refers to articles, it's talking about something specific that relates to that particular organization that's in a form of a contract between that organization and the state in which it was organized under. Dissolution is the act or process of dissolving, terminating, or winding up a corporation. And that can be either voluntary or involuntary. And it goes on to list how these different things can take place. Then organization, as the term is used in commercial law, includes a corporation, government or governmental subdivisions or agencies, business trust, estate trust, partnership or association, or 2 or more persons having a joint or common interest, or any other legal or commercial entity. And then it says, see also charitable organization. And when you turn to charitable organization, it quotes those 133 confusing words I read a few minutes ago. So, when we're dealing with corporations, 501c3 organizations, we're dealing in commercial law. And so to understand commercial law, you need to realize that commercial law regulates commerce, and commerce is strictly defined. It's the exchange of goods, products, or property of any kind, the buying, selling, and exchange of articles, or the transportation of persons and property by land, water, or air. Now, there are 2 other statutes that relate to 501c3. And the first one is 26 Internal Revenue Code, Section 170C2B, which reads as follows. Charitable contribution defined. For purposes of this section, the term charitable contribution means a contribution or gift for the use of a corporation, trust, community chest, fund, or foundation. B. Organized and operated exclusively for religious, charitable, scientific, literary, or educational purposes, or to foster national or international sports competition, or for the prevention of cruelty to children or animals. And the other one that you need to be aware of is 26 Internal Revenue Code, Section 508A and B. And Section 508 is special rules with respect to Section 501c3 organizations, applying for recognition of Section 501c3 status. And it says, except as provided in subsection C, an organization organized after October 9, 1969 shall not be treated as an organization described in Section 501c3, unless it has given notice to the Secretary in such manner as the Secretary may by regulations prescribe that it is applying for recognition of such status, or for any period before the giving of such notice, if such notice is given after the time prescribed by the Secretary by regulations. And Section B says, presumption that organizations are private foundations. Except as provided in subsection C, any organization which is described in section 501c3, which does not notify the secretary at such time and in such manner as the secretary may by regulations prescribe that it is not a private foundation, shall be presumed to be a private foundation. Now, I'll tell you what, that is just about as boring for me to read as it is for you to listen to. But it's important, and hopefully that importance will come out in a few minutes. I have had godly men, good men, Christian attorneys tell me that they recommend that churches and missions become 501c3 organizations so that the members can become good stewards like the Bible says. And they tell me that a good steward will look for ways of preserving that which God has given him. So if he makes a donation to a 501c3 corporation, he can deduct that donation off of his income tax return. Then, depending on the tax bracket he's in, he can get back 15-30% of what he donated. So therefore, by donating to a 501c3 corporation, you're being a good steward because you're getting back a little bonus from the government. That gives you more money to either donate or turn around and use for your own family. Well, I don't have a problem with the logic of a return of a percentage of what you're giving maybe helping out in your being good stewards. But I have enormous problems with the recommendation that churches and missions become 501c3 organizations. Why? A 501c3 organization is a creature of a statute passed by a legislature. As a creature, the creator of that 501c3 organization is the state in which it was organized. And as the creator, that organization is being created by the state. That organization does not have certain rights, such as constitutional rights, according to the United States Supreme Court. I want you to listen to what the United States Supreme Court said in what's become known to lawyers as the Ashwander Doctrine. Anyone who partakes of the benefits of a given statute, or anyone who places himself in a position where he may avail himself of these benefits at will, cannot reach constitutional grounds to redress grievances in the courts. That's from Ashwander versus Tennessee Valley Authority, 297, United States, 288. Now please allow me to show you a little legal sleight of hand here. What was the subject of what I just read in the Ashwander Doctrine? What's the one word in that doctrine that's the subject? Anyone who partakes of these benefits. What's the subject? The subject is anyone. What's the definition of anyone from a law dictionary? First, the word is a compound word, a word made up of two complete separate words. Any and one. One's not listed in a law dictionary, so since it's not listed in a law dictionary, we can assume that it means one. Same thing it means in common everyday language. But the word any is listed in the law dictionary. And here's what it says. Some, one out of many. Any does not necessarily mean only one person, but may have reference to more than one. So what's the problem? To understand the meaning of any, we've got to now discover what the legal meaning of the word person is. Because remember, it says any does not necessarily mean only one person. So let's go look up the meaning of person. And here's what it says. In general usage, a human being. that is a natural person. Though by statute the term may include labor organizations, partnerships, associations, corporations, legal representatives, trustees in bankruptcy, or receivers. Now, you got a question. In this Ashwander doctrine that says anyone who partakes of the benefits of a given person, is that being talked about in legal terms or everyday usage terms? Legal terms. Therefore, anyone does not mean a human being. Anyone means a organization, partnership, association, corporation, legal representative, trustee, trustees in bankruptcy, or receivers. So, anyone that fits in all of those categories that we just talked about, who places themselves where they receive a benefit from a statute, cannot reach constitutional grounds to redress grievances. Now, I hope I'm not stretching things a bit in your mind to make a point. And somebody hopefully isn't thinking I'm pushing the point and running off the deep end, so I need to go to the United States Supreme Court to make it a little bit plainer. And I'm going to read you a section from a United States Supreme Court case from 1976. It says the rights of a corporation that a corporation has differ from the rights a natural person has under the Constitution. Where the Constitution regulates commerce, a corporation has broad rights. But a corporation has only a limited First Amendment right, limited mostly to advertising their products. That's from Virginia State Board of Pharmacy versus Virginia Citizens Council, 425 U.S. 748. In other words, the United States Supreme Court is saying that a corporation, which is a person who benefits from a statute, cannot reach constitutional grounds for redress of grievances. The Ashwander doctrine. Because the rights a corporation has differ from the rights a human being has. Especially in the area of the First Amendment. In that area, a corporation only has a limited right to freedom of advertising their products. The Virginia State Board of Pharmacy case. So what does this mean? Does this mean that a 501c3 corporation, a charitable tax-exempt corporation, has no First Amendment rights except to advertise their products? Well, before somebody starts thinking that I'm telling you that that's the answer, I want you to understand I'm not telling you that. The United States Supreme Court is telling you that. You know, now let me ask you another question. Am I the United States Supreme Court? I'm very glad that I'm not. So let me ask you another question. If you go and talk to another Christian attorney and they tell you, I don't know what I'm talking about, do they know what they're talking about? Because they are contradicting the United States Supreme Court, not me. And do you understand that what the United States Supreme Court rules is absolute law in this country, the opinion of any attorney to the contrary notwithstanding? So if you go and talk to any attorney and he tells you don't believe what he said about corporations and First Amendment rights, red lights and bells better go off in the back of your head. Because that attorney is telling you that his opinion is greater than the opinion of the Supreme Court of the United States. And that doesn't work that way. The opinion of an attorney is only the opinion of a person. It's not law. I just gave you the law which overrides the opinion of any attorney in this country. I don't care who they are. Now let's backtrack a bit. Back to 26 Internal Revenue Code, Section 508, C1A and B. Now, in all of that boring reading, did anybody catch that it said, except as provided in subsection C? Anybody remember that? Don't you think it might be important to find out what subsection C says? Well, let's read subsection C. Exemptions. Mandatory exemptions. Subsection A and B shall not apply to churches, their integrated auxiliaries and conventions or associations of churches. Now, do you mean to tell me that organizations does not include churches? And that churches do not have to become 501c3 organizations to receive tax-exempt status from the Internal Revenue Service, and for the people who donate money to them to be able to deduct it off of their income tax returns? Well, I'm not telling you that. The Internal Revenue Code is telling you that. So any attorney that tells you that I don't know what I'm talking about isn't talking against me. They're talking about anything they can go to a law library and read in black and white. They don't know what they're talking about. Because they're talking against well-established law. Now, if that's what the code says, what does the regulations that correspond to the code say? So we go to 26 Code of Federal Regulations, Section 1.508A2. And it says, an organization seeking exemption under Section 501c3 must file notice. Such notice is filed by submitting a properly completed and executed Form 1023 exemption application. Then right below that, in 26 Code of Federal Regulations, Section 1.508A3, it says, exemptions from notice. Exempts in subsection A, churches, interchurch organizations of local units of a church, conventions or associations of churches, or integrated auxiliaries of a church. So now the regulations for the statutes of the Internal Revenue Service says that the churches do not have to apply for an exemption. Well, do you want a little more proof? I went down to the federal courthouse in Nashville, Tennessee, and I walked into the Internal Revenue Service office and I asked them for this publication, Publication 557, Tax Exempt Status for Your Organization. And this one was revised November 1999. This is the absolute latest word from those folks. If you open it up, if you turn to page 7, bottom right-hand corner, here's what it says. Annual information returns. Every organization exempt from federal income tax under Section 501A must file an annual information return except, anybody want to guess the next word? Churches. An interchurch organization of local units of a church, a convention or association of churches, or an integrated auxiliary of a church. Now I'll also read number 4 at the top left on page 8. It says, and this is still under those exempt. It says a mission society sponsored by or affiliated with one or more churches or denominations. More than one half of the activities of which society are conducted in or directed at persons in foreign countries. They aren't required to file for a tax-exempt status either. This same publication, page 15, up near the top of the page, it's 3 columns right in the center by the top of the page. Organizations not required to file Form 1023. Says some organizations are not required to file Form 1023, and that's the form that is filed requesting 501c3 tax-exempt status. And it says these organizations include, anybody want to guess the next word? Churches. Interchurch organizations of local units of a church, conventions or association of churches, or integrated auxiliaries of a church, such as a men or women's organization, religious school, mission society, or youth group. These organizations are exempt automatically if they meet the requirements of a religious organization, one of the requirements of which is to operate for a religious purpose. And lastly, we'll go to page 21 of this same publication. Bottom right-hand corner of the page, title is Religious Organizations. Below that is bold print that says churches. Although a church, its integrated auxiliaries, or a convention or association of churches is not required to file Form 1023 to be exempt from federal income tax or to receive tax-deductible contributions, an organization may find it advantageous to obtain recognition of exemption. Now, we talked about a little legal sleight of hand earlier. You want to see a little IRS sleight of hand? Okay. This last paragraph that I read and continues over to the top of page 22 has these words. In determining whether an admittedly religious organization is also a church, there is no single definition of the word church for tax purposes. The IRS considers the facts and circumstances of each organization applying for church status. At first glance, that seems to say that the IRS can determine whether an organization is really a church. But when you look at it, what it's saying is the IRS can only make this determination on each organization applying for church status. So, if there's no Form 1023 filed requesting tax-exempt status as a church, the IRS cannot determine if you're a church. Why then does churches apply for a 501c3 tax-exempt status if they don't have to by the IRS's own code, their own regulations, and their own publications? Because they went to an attorney who told them they needed to incorporate to protect their assets. And if they're a corporation, they have to file a Form 1023 to be granted the privilege of being a tax-exempt organization, because remember when we read the definition of organizations, it said corporation. It never said church or mission or religious society or school or anything like that. When the church incorporates, it partakes of the benefit of a given statute, the Ashwander doctrine that we read earlier. And by declaring that the church is now a statutory entity, it must seek permission to receive that which it unquestionably possessed before it became a corporation. Further, by incorporating, no church can reach First Amendment grounds for redress of grievances. The Ashwander Doctrine. Nor can the church claim to possess any First Amendment rights other than a limited First Amendment right to freedom of speech, specifically freedom of advertising speech. The Virginia State Board of Pharmacy versus Virginia Citizens Consumer Council. Now, that's not my assessment of the situation. So I honestly don't care what any attorney tells you about what I'm saying this morning. It makes no difference what they tell you. They're not refuting what I'm saying. They're trying to refute what the Supreme Court of the United States says. And no attorney with a brain in his head, when he realizes that, will speak against that as anything other than well-established law in this country. He might not or she might not agree with it. They might think it ought to be changed, but they cannot refute it. The word of the Lord, spoken almost 200 years ago, comes across the centuries with renewed clarity and understanding today. Remember, we read it a little earlier, Luke 11:52. Woe unto you lawyers, for you have taken away the key of knowledge. How does someone go about undoing a 501c3 status that, if they're a church or a religious organization, does not give them freedom of worship, freedom of speech, freedom of the press, freedom of assembly, or the freedom to redress grievances? That is the crux of these two Supreme Court cases that I have repeatedly talked about this morning. No 501c3 organization has the First Amendment rights that we think we have, because the United States Supreme Court has said they do not have them. And neither of those cases have been overturned by a more recent United States Supreme Court decision. Nor have those cases been overturned by a law passed since those cases by the United States Congress. So no religious organization, I care not who it is, has a First Amendment right to meet on Sabbath or on Sunday, nor do they have a First Amendment right to preach or teach their doctrine or print it. They waived that right when they became a 501c3 organization and a corporation. That's not my opinion. That is well-established law that is in accordance with the rulings of the United States Supreme Court. So how do you dissolve that status? Some clue is given in 26 Code of Federal Regulations, Section 1.501c3b4. It's called Distribution of Assets on Dissolution. And it says an organization is not organized exclusively for one or more exempt purposes unless its assets are dedicated to an exempt purpose. An organization's assets will be considered dedicated to an exempt purpose, for example, if, upon dissolution, such assets would, by operation of law, be distributed for one or more exempt purposes, or to the federal government, or to a state or local government for a public purpose, or would be distributed by a court to another organization to be used in such manner as the judgment of the court would best accomplish the general purposes for which the organization was organized. However, an organization does not meet the organizational tests if its articles or the law of the state in which it was created provide that its assets would, upon distribution, be distributed to its members or shareholders. So the first thing that has to be done if you have a 501c3 corporation and you want to dissolve it is you have to read the corporate papers. Because those corporate papers will tell you how the assets are to be distributed upon dissolution. And if the assets are to be distributed to the members of the shareholders, you did not have a valid 501c3 organization to begin with. And if that happens to be your organization, you could be facing large monetary penalties if the corporation was to attract the attention of the Internal Revenue Service. Hopefully, no one operates a 501c3 corporation with that flaw in it. If the corporate papers direct that upon dissolution the assets are distributed to another exempt purpose, then the procedure to accomplish that purpose must be followed precisely, and that procedure would be in the corporation documents themselves. If you undertake to dissolve a 501c3 corporation and the state gets involved, you can expect the state to step in and take the assets and place them according to the judgment of the court. You are responsible for determining what the proper method of dissolution of the corporation is in the state in which you operate it, or the state in which it is formed. If the corporation was formed in one state and holds property in 2 or more states, you must determine the proper process necessary to dissolve the corporation and distribute its assets in each state in which it holds assets. And the proper way to make that determination is to contact a good corporate law attorney in each state in which the corporation holds assets, because the laws of each state does not have to be the same. If the corporation does not own any real estate, the process becomes easier. In some states, you can wind up the corporation by giving a date and distributing any funds to be used for an exempt purpose. It may also be possible to start a new mission associated with an independent church or with several home churches, and to transfer funds left in the old corporation to the new church or mission, as long as the funds transferred are not excessive. And I can't define excessive for you. That would be defined under the corporate statutes of the state in which the old corporation was incorporated under. You may also be able to notify the contributors that the old organization is being replaced by a new mission, as long as the funds are, and the new mission will be operating on a given date. I would do this very cautiously and not without legal counsel from the state in which the old corporation is domiciled as the best way to wind up the old corporation. If the old corporation owns personal property such as computers, office equipment, motor vehicles, etc., you may be able to sell those items to the new mission. and use the funds from the sale of those items to offset the costs of dissolving the old corporation. However, I would not sell those items to the new mission without the sale price bearing some reasonable resemblance to the fair market value of those items. In other words, if the fair market value of a used computer is $250, I would not sell it to the new mission for $25. You're asking for trouble. I would sell it for no less than 80% of the actual fair market value. There will be all kinds of people and organizations out there that will tell you that in a contract for sale, as long as there is a price agreed upon, that it's legal. And if the thing is worth $1,000 and you agree to sell it for $100 and somebody agrees to buy it, that's perfectly legal. However, don't ever try that in dissolving a 501c3 corporation, because the dissolution of that corporation can be looked upon very carefully by the Internal Revenue Service. And they will disallow the dissolution unless you've paid at least 80% of the fair market value of the items in a transfer. If real property is being leased to the old 501c3 corporation, arrangements must be made to terminate that lease and replace it with a new lease. An excellent structure to hold title to the assets of a new mission or church is a trust. Some banks have regular business accounts that can be opened for churches or religious organizations that do not require an employee identification number issued by the Internal Revenue Service. What do I mean by a regular business account? That is a non-interest-bearing account with the great big checks, not the pocket size or purse size checks. I have been in several banks in different parts of the country where I have told them that I operate a small religious mission. And if I was to consider moving to this part of the country, what kind of checking options do you have available for me? One of the first questions they've always asked is, would this be an interest-bearing checking account or a regular? And the only type of an account you can have is a regular, non-interest-bearing checking account, unless you put your Social Security number on it or a federal employee identification number. Reason is there is no regulation for the reporting of what passes through a regular checking account to the Internal Revenue Service, but if it is an interest-bearing account, there is full reporting requirements to the Internal Revenue Service. Now, I would never close a checking account for the 501c3 corporation and turn around and in the same bank open an account for a non-501c3 organization. I would not even go to the same banking corporation but a different branch. Why? Because most banks, even the different branches in one area, have a centralized bookkeeping location. And the same little minimum wage ladies type in all the information in there. And if you've had a checking account in a 501c3 corporation for a period of time, and they see coming in and they see your name on those checks, and then later they see a new organization coming in, your name on those checks, but those checks written to the same places as the old checks, mark my word, sooner or later one of those little clerks is going to say, you know, that old federal identification number on that 501c3 corporation's not on this new entity, and I don't want to get in trouble because I've got to keep my job. So what I'm going to do is I'm just going to pull that old number out of the old records and I'm going to attach it to this new entity. Then, if the Internal Revenue Service decides to check up 6, 8 months, a year, 2 years later to see if you have in fact quit using the 501c3 corporation, how are they going to check up on it? They're going to punch in the federal identification number of the 501c3 corporation, and guess what they're going to turn up? They're going to turn up the fact that it's attached to another checking account, and you don't want to ever be in that situation. If you think you have endured grief in your lifetime, you have never endured the type of grief you will endure then. So I don't care who you know at the bank, I don't care how much you like it, you can never, ever dissolve a 501c3 corporation and replace it with a church or a mission and open a checking account in any bank with the same name as the old bank. I don't care if you have to drive 100 miles one way to open the checking account. Unless, of course, you enjoy testing and seeing if they're just going to happen to catch up with you. Now, I cannot overemphasize that the proper counsel to seek in dissolving a 501c3 corporation is a corporate attorney in the state in which that corporation was founded. The corporate laws for each state can vary so much that there is no one attorney anywhere that I know of who is competent to advise you unless that attorney practices corporate law in the proper state. Now, I would also be extremely cautious of telling an attorney that we're dissolving a corporation in order to get out from under the 501c3 status, because that attorney's going to look at you and say, you know, you must be Looney Tunes. The way to go about it is to give some simple explanation such as, operating this corporation has become more than we want to do in this point in our life, and we want to dissolve it in a way that's the least expensive, using the assets as far as possible to do the business of the corporation while winding it down. Realize that depending on the corporate documents and the state law, some of the assets may need to be given to some charity, and you may not be able to pick that charity. If you can play a role in picking it, do so. If not, reduce the assets that that corporation will hold to the absolute minimum you can, so that the least amount of it will go somewhere that you can't choose. And lastly, I would never go back to the same attorney that I used to dissolve a 501c3 corporation and ask him for advice on anything about your new church or mission. Because he's going to sit there and he's going to think in his mind, this person must be stark, raving mad. Because understand, he will not understand your reasons for dissolving it. So just like the old bank, you have to cut the ties with the old attorney no matter how much you like him, whether he's your best friend or your next door neighbor. And you have to have a new one for questions that you might have, and you may be responsible for educating him to the fact that you don't have to be a 501c3 corporation. That's your responsibility. There's been a question handed up. Says, what was behind Y2K and what do you know about chemtrails? I guess that ought to wait and go for the round table. because that's off of the subject of this. Lastly, and this is very crucially important, what I have told you today is in no way to be construed as legal advice. What I have done today is I have given you an educational seminar on the requirements of being or not being a 501c3 organization. You are responsible for obtaining competent legal advice from some attorney in the state in which you live before doing any of this. Because I do not have an attorney-client relationship with any of you, nor in dissolving a 501c3 corporation will I enter into one, because I am not a corporate attorney in any state. So any questions that are asked me afterwards will be answered only with the understanding that I am continuing an educational seminar, not giving legal advice. And this is for my protection as well as yours. Under the common law that this country was founded under, the law that was based on the King James Bible, the law that the Constitution, the Declaration of Independence, and the Bill of Rights came out of, under that law, there is only one human being responsible for your actions, and you see them every time you look in the mirror. Under that law, you cannot say, I was an abused kid. I was on Prozac. I didn't really understand, so I trusted this person. That does not work. And when you understand that that law that this country was founded under was based on God's law, in the eyes of God, you are fully and 100% responsible for any actions you take. You can't lay any of that responsibility on me, any other attorney, any preacher, your mother and father for making you do things you didn't want to do, or whoever. You can only lay responsibility for your actions one place. And that's the person that smiles back at you when you look in the mirror. So please understand that. One of the reasons this country has gotten in the position it is because nobody is responsible for anything. There's always somebody you can pass the responsibility off on. And that is neither Christian, nor biblical, nor lawful. Under the founding laws of this country, or under the higher laws of heaven. With that, let's bow our heads for prayer. Our Father in heaven, we thank you for your blessings. We thank you for your watch care. We thank you for the intelligence that you've given us. And dear God, if we don't understand something completely, we thank you for the promise that if any of us lack wisdom, that you will give it to us. And we pray that as this earth's history is winding down, that we use that God-given wisdom as well as that God-promised wisdom to do the things that we need to do to make the preparation to go home with you. Because in the final analysis, God, we know that if we don't make it to heaven, everything that we've done down here on earth must have been done for the wrong reasons. And more than anything, I want, and I believe these people want, to be able to spend eternity in heaven where we can be truly free. We ask this in Christ's name. Amen.